Hello, everybody. Let me turn that off real quick. Hey, welcome to this video here. Sorry, I'm getting all my screens here together and ready to go. Put this one down here. There we go. A little bit better. Yeah, so yesterday, I think it was yesterday. That was a few days ago, 3 days ago, but I just found out, my grandson's scaring me. Ah! Anyway, 3 days ago this week, let's just say this week, the 7th District Court in Amarillo issued a memorandum opinion again on the Waller County. Now, for those of you who don't know, early, in 2015, 2016, well, heck, even to this day, we have been fighting in open carry Texas and beyond a lot of these cities and these counties and these municipalities that are unlawfully prohibiting and banning guns inside their buildings. And one of the things they're trying to do is claim that the courthouse exception. So and a lot of these are smaller towns and smaller counties. And as you know, in the smaller towns and smaller counties, they don't have the kind of money that large cities and municipalities do and large counties to put courts in one building and their city council in another building and their treasurer in another building and all that kind of stuff. And so many of these smaller counties and smaller cities in Texas will use one building for all of their operations. And they will claim the exemption that it's a courthouse. So just because 1 day a week or 2 days a week, there is a court being held in one room of the building, they'll try to exclude gun owners. And this has been a fight for a long time. And we've won most of these fights, but Waller County is the one that just never seemed to die. And you might remember this case because Waller County it's the county courthouse, but it's only a courthouse in the traditional sense. That's what the building was way back in the day. Now, is there a court in there? Yes, but almost every county function is also performed inside this building. And so a lot of gun rights activists, Terry Holcomb was a lead on the Waller County case. He filed a complaint with the Attorney General about the fact that Waller County was preventing people from being able to carry their licensed firearms into the building, even if they weren't going into the court, if they weren't a plaintiff, they weren't a defendant. It didn't matter. They were trying to claim that the entire building was off limits, and what they did was they posted a 4305 sign, and we're going to look at that in just a minute. And so, or 4603, not 4305. I'm dyslexic apparently. A 4603 sign. And so what that is under 4603, which is places where weapons are prohibited. One of those places is the building. Actually, I'll just show it to you here. Let me bring up I'm going to have to add this screen. I've got 3 screens going on over here. Oh, I didn't have that one up. Why don't I have that one up? Oh, let me share this real quick. Share. Come on. What are you doing here? Why is this not letting me share the screen? Share. Oh, I guess I can only do one at a time. That's why, maybe. All right, let me just change screens, I guess. I'll figure this thing out. Don't worry. All right, so under Government Code 46. Oh, no, I'm sorry. Penal Code. What am I doing? Penal Code 4603. And this is where weapons are prohibited. All right. Oh, son of a gun. I'm just going too fast for myself. There we go. Go. Thank you. All right. One of the places that is banned is on the premises of any government court or offices utilized by the court. Okay, that's one of those things. Now, the problem here is the definition of premises. This is where we have had so many disagreements about what this means. And the code defines premises right here. It means a building or a portion of a building. Now, here's where you look at the law and you look at it for its plain meaning, a building or a portion of a building. If the intent of the legislature is that if there is a courtroom inside a building, then that makes the entire building a prohibited place, you would not even need this right here, because that's just a small part. But I think the legislature recognized that there are multi-use buildings that do house things beyond just the courthouse, because Texas is a large state. We've got small counties, we've got large counties, we've got small towns, we got big cities. And so if the entire building is nothing but a courthouse, well, then obviously that building will be off limits. But if there is a building that houses a courthouse, for example, there are several counties in the state of Texas where the city council chambers is also used once or twice a week as the courthouse, the municipal courthouse. Okay. So you've got the city council chambers there, and you've also got the courthouse that uses that. And it's also used for other functions as well. So it's a multi-use room. And there are attorney general opinions out there that these types of places do not qualify as, places that you can withhold a gun owner. Now, so what happened was in Waller County, the attorney general sued the county because he believed that, and I think he was right, that Waller County was improperly and unlawfully preventing armed people from coming into the building against the law. So Waller County tried to file a motion to dismiss. They were claiming, Waller County was claiming that there's no jurisdiction because the pleading from the attorney general included pleadings that occurred that was quoting law after essentially this had taken place. I've got here, let me again change the screen, but before I do, because that's going to be a pain in the butt, I'm going to go over some of the sections of the law here. So this is section 411-209 of the government code here. I'm going to make this large. I'm going to hide my screen. Never mind. Y'all can't hear me if I do that. There we go. Now you can hear me. What this does is this shows that it's the wrongful exclusion of a handgun license holder. This is where we get our teeth in being able to sue government entities that are violating Texas law. So what this says is essentially that a state or political agency, you cannot keep people from coming into a building under 30 and 36. If it's a license holder, you just can't post a sign. And it says that if you post a sign that says you're prohibited from entering or remaining on this premises or other place owned or leased by a government entity, unless they are prohibited under 4603 or some other law, right? So then later, down in section H, this is how, because generally government has what's called sovereign immunity. We all hate the word immunity because it allows bad actions by government. And the only time you're able to really sue government is if the government itself lets you sue them. Now, the federal government has created causes of action, for example, under 1983 and others, Title VII, things like that. But this is the specific statute that allows you to sue a local government entity for violating the law instead of just, going to jail and having to fight it that way. And this is what's going to come into play here in this case, because back in 2015, this went into effect. September 1st, 2015. So this was passed in 2015, and it talks about the wrongful exclusion. And this is going to come into play. I'm going to try and make this let me make this very simple to y'all. Even though the court found, and let me go back to just me here. I lost my cursor. There it is. Even though the court found against the Attorney General, it's kind of a weird case in which they did that. The Attorney General, in his opinion, brought up the fact that after the fact thing. So when you file a case against the government or really anybody, you can only argue and use the law that's in place at the time of the lawsuit. So if I file on March 1st of 2022 and the law changes on March 5th, 2022, I can't invoke the law of March 5th to support my lawsuit of March 1st. That's the way things are. You can't do it that way. So you've got to go with the law. Now, I could have waited till March 5th if I wanted to. Here is the lawsuit that we're going to be discussing today. This is the actual opinion. If you want to look up the number and look it up yourself, there it is. Oops, I've got my, there we go. I've got my highlighter on. You can look up the case number. That's the case number. You can read the entire thing yourself. I'm only going to bring up a few things here because on one hand, I'm not sure exactly where the court is coming from. On the other hand, I see where the court is coming from. There are issues here where the governor was wrong in creating this lawsuit. So this talks about the statute that I just told you about, 411-209. It allows a civil penalty for a state agency. This is the sign that was at Waller County. And it's essentially a 4603 sign. Pursuant to Texas Government Code, what they're claiming is that this entire building, even though there's only one room in here that constitutes a courtroom, and I think this is like a 3-story building, if I remember correctly, because I was there. It's like a 3-story building, if not 4. And so of that, almost everything else is not a court. But this sign up here says that pursuant to Texas Penal Code Section 4603, claiming that on the premises of a courthouse, and then you go and look at the definition of premises, which is a building or portion of a building. That's what they're claiming is, and this is going to play a big part in this case and why it lost. They didn't lose because they were excluding license holders. They lost because, one, the interpretation of the law, and 2, because of the fact that the Attorney General was arguing law that had not been enacted yet, law that happened after the fact. So the county filed a motion to dismiss for lack of jurisdiction. It talks about all that kind of stuff. And here's again in June 2015, this was the language here. And what's going to be really important, and this is where what I'm going to center in on. I'm going to go through a lot of this really quickly. But, the law or the sign that comes in there has to specifically mention Section 3006. As you can see up here, as you could see up there, it didn't mention 30.06. It mentioned 4603. Or, and this is the part that I highlighted, or by any sign expressly referring to 30.06. Okay, it didn't do that. Or to a concealed handgun license. This is what I'm going to argue here, and where I hope that the Attorney General fixes this. Because I still think the Attorney General can amend this, and this section right here, or to a concealed handgun license, I still think would allow for jurisdiction in this case. So the Attorney General alleges that the county was in violation because it prohibited possession of handguns from the entire premises. And the county maintains, by its own admission, non-judicial county administrative offices, as I said, like the county treasurer and the elections office in that building. there's no requirement for signage under 4603, none at all. Just because you're a courthouse doesn't mean that you have to say you can't come in here because 4603 says no guns in a courthouse. Just like a school doesn't have to put up, hey, you can't come in here because 4603 says no guns in schools. They don't have to put up a sign, but they made its own sign. What the Attorney General did was that he said not only were these signs in violation of laws that were in effect 2015 to 2017, and I believe this was filed in 2015, but also he invoked laws from 2017 to 2019 and 2019 to present. Now, that was the amended complaint. So he had the original complaint, and then, of course, time went on, the court dragged on, the case drug on, and when he amended the complaint, he added additional details about what the law said after the lawsuit was filed. And the court's going to talk about how you can't really do that. And then he also talks about some oral communications that were made by the sheriff's deputies that were guarding the building in 2016, 2017, and 2018. Obviously, the lawsuit was filed in 2015. So these 2016, 2017, and 2018 statements that were made can't be used as a basis for the court to determine whether or not jurisdiction has happened. I'm trying to get through the boring stuff. And this is where the court says, look, we can only look at the law that was in place at the inception of the lawsuit. So they threw out everything the Attorney General said after the fact, after 2015, and only looked at the law under 2015. And this is what they came to. There's a case here, City of Austin, that there must be, they can't put notice out there that describes 3006 or any sign expressly referring to that law or license to carry a handgun. And then, so they considered, okay, does the sign in question here, does it actually describe section 30.6? Well, no, it doesn't. The court makes a whole lot of words here and says, no, it doesn't, because here's the sign. I read it to you earlier. Pursuant to Texas Penal Code section 4603, remember, 411.209 only expressly refers to 30.6. So this is referring to 4603. I mean, it does talk about 4605 as well. But so the court said, okay, I don't see anything here about 30.6, so it doesn't meet that element. And they're not in violation. So next we consider whether the county sign is any sign expressly referring to section 30.6. So it's not a 30.6 sign itself, but now does this sign that the county put up actually refer to 30.6? That's the next thing that the court is looking at. Well, no, it doesn't refer to that. And so, but here's the part that I think I disagree with, and I'll tell you why. And this is where I hope the Attorney General is also looking, because he says, we therefore conclude that the county sign is not a sign expressly referring to section 30.6 or to a concealed handgun license. And the reason I say that, because, and these are just some other things here, you know, where the text is very clear, text is determinative of legislative intent. And that's what I'm going to talk about, this legislative intent. What was the legislative intent when this law was passed? And I'm going to tell you. And then we must enforce the plain language of the unambiguous statute. Now, in the unambiguous statute, it talks about specifically a sign or referring to a concealed handgun license. Now, back in 2015, as you remember, the only way you could carry at all outside of the home and outside of the car on your person anywhere in any building was with a license. There was no such thing as unlicensed carry. It was inferred. It was well known. It was the legal doctrine for the past since 1995 or 96 when it went into effect. Since 1996, the only way that you could carry a handgun in Texas was with a license to carry or a concealed handgun license at the time. So when the law here says that when the 411.209 says any sign expressly referring to 3206 or a concealed handgun license, well, this sign does that, because the sign says a person commits an offense if the person intentionally, knowingly, or recklessly possesses or goes with a firearm. How do you go with a firearm in 2015? Remember, we've got to look back and pretend that we're back in 2015 and we are adjudicating this case as if we are living in 2015. In 2015, there was no such thing as unlicensed carry. In 2015, there was no such thing as constitutional carry. You had to have a license, and you could only carry concealed at that time, because it wasn't until 2016 that we were able to carry openly. And so when it says here that goes with a firearm, it's inferred, it's obvious to the law, to the legislature, to the courts, to everyone, or at least it should be, that the only way to go with a firearm is with a license. Therefore, yes, this is referring to a concealed handgun license holder. Just as it says down here, the county sign is expressly referring to a concealed handgun license. Why? Because you have to have a concealed handgun license to go with a firearm. So I'm hoping that that's the argument that he makes, because, if that was the argument today, it might be a little bit different, because it doesn't expressly refer to the license, because now you don't need a license. But again, back then, that was the only way you could carry. So what the court has done is it essentially threw out the lawsuit against Waller County. So Waller County wins. However, they're remanding it back to the trial court and allowing the Attorney General 30 days to amend his pleadings to demonstrate the existence of jurisdiction. If he doesn't do that within 30 days, or he can't demonstrate the existence of jurisdiction in that court, in other words, that the law applied to this sign, then it's going to get tossed out anyway. It's going to get dismissed. So the Attorney General has 30 days. Obviously, we'll be talking with the Attorney General, find out, hey, because we've been involved in this since the inception of this anyway. So no, we can't use the Bruin decision either. Remember, we have to, when we're looking at this case, we're looking at this case in 2015. That's when the case was filed. We have to use, even though the law has changed dramatically since 2015, we have to go by the law at the time. And so the Bruin case won't necessarily affect this, and I don't think it would affect it anyway, because they could claim under the Bruin case that a courthouse is a sensitive area, and historically courthouses have been adjudicated as sensitive areas and banned for having guns there. So while this is a loss, it's not really a loss, and even though it's a loss, it's not a loss really for the right reasons. This is really a very sort of technical loss. It's a technicality, and the county is still wrong. It's just not wrong in the way that the Attorney General claimed it's wrong. And I think the way that I would amend it, I mean, I'm not the Attorney General. I'm not even close to being as experienced as the Attorney General in the matters of law. But a plain reading, I think, shows that that sign that Waller County had up did refer to a concealed carry license, because if you didn't have a concealed carry license, you don't need a sign anyway, because not only without a license could you not carry into the building with or without the sign, without a license, you could not carry walking up to the building. Once you left your car, you were not allowed to carry a firearm because you needed that license. So that's where we are with the Waller County case. The media is trying to spin this as if Waller County is right, that their signage is correct. Keep in mind also that while the signage might be correct in 2015, as the Attorney General argues, it's likely not legal today. And so if this gets tossed out, all the Attorney General has to do, and this is why I hope the court just deals with it now, but again, it can't. If there's no jurisdiction, there's no jurisdiction. And once you plead to the jurisdiction, it's the duty of the opposing party to prove the jurisdiction. The plaintiff has got to prove that this is the right court that the case should be seen in. And if the county did not lose its qualified immunity, or its sovereign immunity, not qualified, its sovereign immunity, because its signs did not comport with the law of 411.209, then it's going to get tossed out. But the Attorney General, I think, can win in two ways. One, he can just say, you know what, screw it, we're going to let this go, and we're just going to refile under current law, provided those signs are still up. I don't live in Waller County. I know there is somebody in the chat that lives in Waller County, and I do agree that cops in Waller County are very dirty. The entire political process in Waller County is pretty dirty. We've gone up against them for years now. I haven't been there in a while, but it's a pretty dirty place. So I don't know if those signs are still up there. Maybe some of our Waller County viewers, I know I see at least two of them, can go and look and see if those signs are up. And if they're up, you know what? All the Attorney General, again, has to do is just file a brand new lawsuit, essentially allege the same thing, just under the new law. So it's not like you're doing the same lawsuit twice, because now you've got different laws that apply. And because those different laws apply, it's a whole new case and a whole new controversy. All right. And I think he also can win just by saying that, look, this is the plain language. Under the plain language, Waller County is saying you can't bring a firearm in here. Well, that only applies to concealed carry license holders, because only concealed carry license holders can even carry a firearm. So just because it doesn't say concealed carry license, it expressly refers to bringing firearms into the building. All right. I think I've kind of beat that dead horse. All right. So let me get into some of the questions here in the chat. Let me go back to the beginning and see what we've got, if anything, and then I'm going to close this up. Hey, Skip, what's going on, brother? How's the baby? Probably not a baby anymore. A little toddler now you got running around there. Let's see. I just got here. I live in Wall. Okay, yeah, that was don't mess with Texas. Maybe you can let me know. Hey, don't mess with Texas. Check and go see if the courthouse is still posting these 4603 signs. I'd kind of like to know. Leon Valley comes to mind. A lot of cities come to mind, man. A lot of cities come to mind. This Tommy Larson, I don't accept anything from Merb. Yeah, Merb's a California attorney. That's why I don't really give a shit. I don't answer to Merb. I know a lot of his mindless drones would like me to, but I don't. Do you even know what law Merb practices? I don't. Oh, talking to Tommy. I don't know. I don't even know, because I don't really care. I mean, the only time I even know he's talking about me is because other people tell me he's talking about me. All right. Anyway, I don't want to make this about that. Oh, he's family law. Okay. And you know what? If we debated, you know how Merb can beat me is if we debated family law, because I intentionally did not, and I do not practice family law. I got a call today about asking if I would do a divorce, and I said, nope, not touching family law. I got friends, close friends, who are dealing with family law issues. Nope, not going to do it. That's a whole new beast. And that's not what I went to law school for. Could I? Yeah, I probably could. I don't want to. Cops here in Waller. Let's see. Good news. There are 200 counties in Texas outside of this. Yeah, it's true. Very true. I think I already talked about the Brune decision. You know, I've talked with Colin Noir several times. I think it'd be kind of neat to do a show together, but you know, he's a big shot guy. I'm a nobody here in Texas. Well, I think he's in Texas too, isn't he up in Dallas or down in Houston? Colin Noir's in here somewhere here in Texas. Let's see. Watch the video about Waller from Freedom 2 Films channel. Yes. Let me show this. Go check that out. That's actually a really good video. I think I got everything. More talk about Merb here. All right. Yeah, and just so you know, I mean, I've got 5 times the viewership of Merb. So, of course, he wants to debate me so he can increase his numbers. I mean, that's what he wants. He wants attention. And the only way he can get attention is by having other YouTubers. I've probably just given him more attention than he'll get all week. All right, I'm done with that. All right, so that's it. He's from Houston, but in Dallas now. Okay, I knew there was some kind of correlation there. Yeah, he's in Dallas. All right, guys, that's the decision. Again, let me bring this up. I want to show you the numbers so that you can, look it up yourself if you want to. These are all available for anyone to go to look at. All you've got to do is type in that number there, go to the 7th District of Texas. And this is also kind of weird to me. Amarillo could not be further from Waller unless it were El Paso. It's kind of weird that it went all the way up there. And I have to wonder if they were district shopping. I don't know. I haven't looked and seen what the, what the 7th District covers. So, I mean, it may just be that the 7th District covers Waller County for all I know. I haven't looked because that's not something I necessarily care about yet. On appeal for the 98th. Yeah. So this makes sense that it would be Travis. So I guess that's the next higher court. Anyway, all right, you guys take care. Be safe, be free. I am, as little things come on here, I like doing these live. I'll tell you why I like doing these lives. For one, you get to see whether or not what I'm saying to you is sincere. It's not engineered. It's not cut and spliced. It's not a production value. It's you and me. And I say things, and sometimes I'll say something, and as I'm going through, I realize I misspoke, and I'll fix myself. I prefer to have this open dialogue as opposed to a really nicely produced video. I think it shows, one, that I know what I'm talking about. I don't need a bunch of edits to make myself sound good. And I sound just like a normal person because I'm umming and awing, and sometimes I might be repeating myself numerous times. So I prefer doing it this way. I know a lot of people don't watch me live. They watch me after the fact. But I don't edit my videos. And I do that so that no one can claim I'm editing my videos and editing out stuff that's important or editing out embarrassing things, because I have no shame about anything I do. If I'm ever wrong, I apologize for being wrong. I have no problems with doing that. And because I'm going to be wrong. There are many times that I'm going to be wrong. So, John, what's up, man? Welcome. And I'm about to show up. You showed up late, and I'm signing off right now. You guys take care, be safe, and be free. Don't forget to check out this video here, the video about Waller County from Freedom to Film channel. Check that out. And again, I'm not saying there's anything wrong with people editing videos. I'm just saying, if I'm going to get up here and talk about the law, I want you to know I know what I'm talking about. And the best way to do that is just to show you by talking to you. All right. I do actually have work to do. I do have clients that I got to get to and legal work to do, despite the fact that people are trying to claim that I can't do legal work. It's weird. It's weird that look at all these. I wish I could. I mean, it's a laptop camera, but I have case files. These are just 2 of them that I was working on today. I've got more case files over there. I closed out 2 cases today. Yes, I'm doing legal work. And if you don't like it,